So welcome everybody, I'm Elizabeth Beattie. I head up the in-house lawyer services at Harrison Clark Rickaby's, and today is the third in a series of weekly webinars on various topics. And today my colleague Dan de Saules is going to talk about contract essentials, and we're going to look at the challenges and opportunities around cancelling, renegotiating and varying commercial contracts and GDPR in light of COVID-19. I will hand over to Dan shortly. When Dan's completed his presentation, there'll be a question and answer session. For those who've sent questions in beforehand, we'll go through those then. But if anybody who'd like to raise a question during the course of this webinar, if you use the Q&A button at the bottom of your screen and put a question there, we'll pick that up later on in this session. So, as I say, welcome, and I hope you find it useful. And now I'm going to hand over to Dan de Saules.
Thank you very much, Beth. Hi, everyone. I'm Dan de Saules, and I'm a solicitor in the commercial team here at Harrison Clark Rickaby's. And today I'll be discussing various key issues that have arisen from COVID-19, specifically in relation to commercial contracts. So today's talk, I'll be mentioning four main topics. The first one being force majeure issues, obviously given that this is a very key factor sort of coming out of COVID-19, and later on in my talk I'll be actually taking you through an example force majeure clause, along with briefly touching upon elements of frustration. Secondly, we'll go through variations to contract and some of the key terms to consider there and how we actually affect a variation to contract. Thirdly, I'll then go on to talk about electronic signatures, in obviously carrying on from variations and generally in terms of contract signing. And then last but not least, we'll finish on GDPR, and I will be exploring some of those issues that have arisen during COVID-19. Next slide, please. So firstly, I'll begin by briefly talking about how the legal landscape has changed since COVID-19. So pre-COVID-19, businesses could, within reason, operate with much more freedom, obviously subject to engaging in fraudulent activities, corruption, bribery and the like. Today, however, we've seen kind of new coronavirus laws come into force through a series of primary and secondary legislation across the UK, and as we've already seen, some of these laws have been interpreted and indeed applied differently across the UK, most notably the travel restrictions and the social distancing generally. So the new legislation that comes into force, we've got the Coronavirus Act 2020 and the Health Protection Coronavirus Restrictions Regulations 2020. Now, I won't go into these in great detail, but just a general overview of these acts. The Coronavirus Act mainly outlines the operational details of what the coronavirus is, so it provides us with a definition, the provisions for health professionals there, it outlines some investigatory powers and provisions for statutory sick pay. Now, the health protection regs contain the powers of the restrictions and the requirements that aim to counter the spread and the effect of the coronavirus. We've also seen new government schemes such as furlough introduced, which I won't go into in this webinar. However, as you may be aware, we've done quite a few employment webinars on furlough. So they are available to view on our website, but hopefully you'll stick with this one first before going on to those. Needless to say, obviously these new acts and restrictions have already and will continue to change the legal landscape which we once knew. Next slide, please. So we are seeing more sectors of the economy increasing productivity, so manufacturing, construction, logistics and distribution sectors. They're continuing to see increases in activity, and likewise the hospitality, retail and leisure sectors are slowly now beginning to increase their productivity as well, and should accelerate later this month. Now more than ever, contractual negotiations and variations are pivotal to ensuring sort of stable futures by adapting to this new changing business climate which we're in. So what are the sort of key terms that we should be focusing on? Well, one of the main ones is obviously price and payment terms. It's the most obvious change. But could this be simpler by offering, for example, one-off discounts to counterparties without actually varying the contract or changing your traditional pricing terms at all. So for example, if you're looking to extend credit terms, always consider whether this is a good idea given COVID-19, or if this simply masks a potential deeper debtor payment problem that's sort of been in the pipelines for a while. Delivery terms, so are these still practical and achievable? Do lead times need to be varied or extended? And obviously linked in with that, are there any service levels that need to be sort of relaxed? And obviously that links into services contracts as well. Or can orders actually be collected for a period of time? Forecasting, so usually forecasts are obviously expressed as non-binding. However, these should still be sort of discussed and explored between the parties, so just to get that accuracy and that foresight on any future orders. And obviously linked in with that is obviously minimum purchase obligations, so are there any in your contracts, and make sure that you are sort of reviewing those so as to avoid a potential breach of contract. And I think the biggest kind of awareness on on sort of variations and negotiations of your contracts are being familiar with the wider contract terms. So consider what else may need to be varied or at least considered. So for example, who bears responsibility for any additional costs of storage or general costs for non-delivery, as we've seen throughout COVID-19, and various businesses have been forced to shut down. So just think about those extra costs and who bears what. And also what terms will apply in the event of insolvency. So particularly around payment and passing of title if we're dealing with goods. And in the worst case scenario, it's probably a good idea to have one of these in anyway. Is there an exit plan in your contract? Next slide, please. So once you've agreed with your counterparties which terms are to be varied, well, how do we go about affecting that variation? Well, most contracts will contain variation clauses, and on the slide we can see these are usually along the lines of no variation shall be effective unless it is in writing and signed by both parties. But parties, very much importantly, must always stick to the specific express wording of those variations and any continuing obligations that are provided within that. An example of a very, very relevant case is the Great Demo case, as we can see on the slide. So the brief background to this is the case concerned a contract for the sale of land. There's an issue surrounding the valuation of the land. The parties subsequently entered into the contract for the sale, but the issue with the valuation was to be later decided by a statement of agreed facts, which was then subsequently entered into. Now, the question here was whether that statement of agreed facts actually constituted a valid variation to the contract to sale. And we can see the actual variation clause on the slides, and I'll give you a couple of moments just to read through that. So as we can see, there are quite a few hoops to jump through in this clause, and the Court of Appeal actually acknowledged that the parties to the agreement could bind themselves to a specific method of making the variation to the contract, but crucially, the parties had to comply with those specific conditions in the clause. Subsequently, in this case, the Court of Appeal decided that the statement of agreed facts didn't actually constitute a valid variation in that clause. Now, there's often in this situation an argument that once the parties deem the contract as varied and obviously have performed and acted upon that and may have also incurred costs in doing so, does this make the variation valid? Well, this could give rise to issues around estoppel, for example, and this case has actually been referred back to the High Court to specifically answer that issue of estoppel. So it's very much watch this space on this case, but I think the message is clear that once you have agreed terms to vary the contract, make sure that you actually take note of what the variation clause says and then go from there in terms of jumping through the hoops. Next slide, please. So given the current situation, obviously variations to contracts and indeed entering into new contracts generally are very much being entered into electronically, a lot more so than they used to be. As a general rule across England and Wales, electronic signatures are legally enforceable, and this is confirmed by the Law Commission of last year. You got the relevant citation there. However, the key thing is intention to sign electronically, and if there are any formalities that follow, these again must be satisfied and strictly adhered to. For example, electronic signatures do pose issues with the contracts for sale of land and also deeds. So documents can be executed by deed, obviously electronically, and they can pose issues purely because currently the law does not allow for remote witnessing when the witness is not physically present. So for example, if you are trying to sign a deed by Zoom or Microsoft Teams, there's very much a grey area there as to whether that is actually physical witnessing of a deed. But technically it's not, because it's remote and it's electronic. But saying that, there are ways for a company to actually execute a deed electronically, and this could be done via the two authorised signatories as outlined in section 44 of the Companies Act. And the Law Commission has actually approved this method of execution, and importantly there's no actual requirement in that specific section of the Act for signatures to be applied to the same signature page at the same time. Now, sometimes arising from that, there are issues as to actually who has authority to sign the variations or enter into new contracts electronically. But there are electronic signing platforms out there, such as Adobe eSign and DocuSign, and these are increasingly being used as they offer further protection in terms of verifying the signatures, and also it creates, importantly, a digital audit trail, which can also be password protected. Next slide, please. So, force majeure, obviously a very key issue arising from COVID-19, but before we kind of dive into the mechanics and the specifics of force majeure, I think it's relevant to actually take a step back and just to consider how force majeure clauses were viewed prior to COVID-19 and pretty much how often they're exercised. So pre-COVID-19, it was not uncommon for force majeure clauses to be very short form, less detailed and inclusive of catch-all wording, which aimed to cover a variety of events which were beyond the parties' reasonable control, without specifically mentioning those events, for example, natural disasters, acts of terrorism, fire, floods, etc. Force majeure clauses can and often are subjective, and they can be open to interpretation, and they have been traditionally seldom used, with most of them kind of being exercised within the oil and gas industries. Now, with COVID-19, the situation is much different, and most lawyers are obviously considering introducing new bespoke force majeure clauses into contracts, or seeking to amend those existing contracts by inserting explicit force majeure wording. So as we know, force majeure clauses generally excuse one or both parties from performing their obligations under the contract upon the occurrence of certain events which are outside of the party's control, and that's the phrase we often see. When such a clause applies, the party is then excused from its obligations under the agreement, either permanently or for a specific period of time. It often depends on the wording of the clause. So importantly, there's obviously no single definition of what is a force majeure event. It's very much based on common law, and so force majeure clause, if you're drafting it or if you're reviewing one with a view to exercising it, it must contain one, a specific list of events, and two, the catch-all provisions. So a clause that simply talks about force majeure without further defining it is likely to be too uncertain in its meaning to have any effect at law. Now, most existing contracts, commercial contracts before January 2020, are highly unlikely to include specific reference to the coronavirus as a separate force majeure issue. And obviously where the contract contains a specific list of force majeure events, a court is probably likely to say that coronavirus is covered as force majeure event if the language includes epidemics or pandemics, which is often what we do see in a force majeure clause. Importantly though, just wanted to touch upon the case of Tandrin on the slide. So in this case, there was a force majeure clause with a list of specific events, and this was followed by the catch-all provision, which covered any other events beyond Aero Toy Store, ATS's reasonable control. Now, ATS sought to rely on that catch-all provision to say that the 2008 financial crisis was an event beyond the party's reasonable control, which triggered the force majeure event. However, the court actually held that the force majeure clause did not cover the crisis, and this was because neither the economic downturn nor any similar wording was actually included as a specific event within that clause which would apply. So over the next couple of slides, I'll actually be taking you through an example force majeure clause in light of COVID-19. However, I must stress that obviously this is for usual lawyer caveat, for illustrative purposes only, and must not be sort of copied or taken as legal advice. So as you can see on the slide, we've got the first part, the force majeure clause, so I'll give you the moment to read through that. So firstly, looking at the wording in clause 1.12 in bold, this addition aims to extend the meaning of pandemics to expressly include COVID-19, excuse me, which could be important to cover a second wave of the coronavirus. Notably, issues such as government restrictions arising from the coronavirus could actually be deemed and called within this clause as a force majeure event. But obviously, note the wording must affect parties' performance of the obligations under the agreement. So traditionally, in relation to force majeure, causation is key, and if a party is to excuse itself from contractual obligations under the contract, that party must prove that the force majeure directly affected or prevented it from doing so. And the bold text in clause 1.2 gives effect to its overall position. Excuse me. And depending on who you're representing, as a customer or supplier, thought should be given to which one of those words in bold that actually you use. So, for example, hindered or delayed in performing obligations sets a very low threshold to overcome, rather than being prevented from performing its obligations. Equally, the wording all or a substantial part of its obligations confers a much higher threshold than any of its obligations. Next slide, please. So on this slide, we've got the second part of the force majeure clause, which often details what the affected party who experiences a force majeure event must do. Again, I'll give you a moment just to read that through. So, as we can see in this clause, 1.4 contains a notification requirement for the affected party to notify the other party of the effects of the force majeure event on its capability. Excuse me. On its capability to perform the contract. And crucially, if such notification requirements are not met, then the party seeking to rely on the force majeure clause will face an uphill battle. Clause 1.5 in bold is for the benefit of both parties, and this very much aims to ensure a collaborative approach in dealing with the force majeure generally, even if terms need to be varied as a consequence. And again, that should be the approach I think that parties should be adopting in any event. Similarly, we've got clause 1.7, which aims to promote and continue performance of the agreement as soon as possible after the force majeure event ceases or no longer causes a hindrance to the performance of the party's obligations. So here we must consider whether the force majeure event needs to cease completely before the contract can continue, or whether the contract can continue if the force majeure event dilates. So this is particularly relevant in relation to the ongoing government restrictions, despite the virus hopefully petering out. Now, historically, the courts have looked for evidence of mitigation in relation to force majeure events and whether a party has taken reasonable precautions. Clause 1.6 of the on-screen example touches upon this briefly. However, the point is better illustrated, and there's a recent case of this, which is To Entertain and Sony. And this is a 2020 case. So in this particular case, trespassers broke into a Sony store. They set fire to and damaged various pieces of equipment. Some of this equipment was owned and belonged to Entertain. Now, the trespassers were part of and were linked to ongoing rioting at the time, which was pertinent at the time of the attack. Now, the relevant force majeure clause in the contract between 2Entertain and Sony did cover events beyond the parties' reasonable control, again that phrase we see, and it expressly included fire as a force majeure event. However, it actually held that Sony could not rely on this clause, and it was due to the fact that the court said that Sony had failed to take adequate security and fire prevention measures that would have been expected and taken by a like business, or should have been taken reasonable like business in the same situation. Now, the issue of foreseeability here was pivotal, and the courts expressed that because such rights were ongoing and had been for a couple of days, I think it was, before the actual break-in, the attack was foreseeable. Now, that example may be relevant, or the theme from that example may be relevant to the coronavirus and future business planning should a second wave of the virus occur, notwithstanding obviously the wording in the actual force majeure clause itself. So that's very important to take note of the case. Next slide, please. So what happens if there are no force majeure provisions in a contract which deals with delay, non-performance or termination upon the happening of a particular event? Well, the doctrine of frustration may apply. And even where the contract does contain a force majeure clause, well, frustration may still apply in any event if the definition of force majeure event is inadequate. Now, frustration is a common law construct, and the wording on the board is key for what the courts look at. So where parties' obligations under a contract, they will be deemed discharged where an event occurs after the formation of a contract which makes it physically or commercially impossible to perform, or which transforms the nature of the parties' obligations to a contract in a significant way. Now, the courts will also take into account whether the frustrating event is foreseeable at the time the contract was entered into, and whether this is so fundamental that it goes to the root of the contract and beyond what the parties contemplated at the start of the contract. Now, it's important to note that only the courts can decide if a contract is frustrated, and the bar is set very high on this threshold. And to date, frustration has been applied very rarely. As we can see on the slide, the key precedents on frustration date back to the coronation of Edward VII in 1903, which I'm sure none of us can remember that. But more recently, however, cases on frustration, when this is raised as an argument, the courts have tended to deal with this as a matter of contractual interpretation, therefore moving away and drawing the arguments away from frustration, because it is such a difficult argument and it is a high bar to overcome. Now, if frustration is proven, what will happen is the contract will be automatically discharged and brought to an end. And the act that governs the frustration concept is the Law Reform Frustrated Contracts Act 1943. Now, this lays down remedies in the event of frustration occurring, but importantly, and people tend to forget this, the actual remedies aren't that great for either party. And that's because the main remedy on a basic level is a recovery of expenses before the frustration event occurred. It's usually nominal amounts. So in short, it is always useful before you're going down the frustration route just to check whether there are any other avenues in your contracts before exercising frustration. Next slide, please. Okay, so GDPR. So firstly, what should we be aware of, and can businesses simply continue to process and store personal data as they've previously done so? So given the current situation, organisations may be tempted to collect, and they have already collected, copious amounts of information as much as possible from their employees regarding the coronavirus outbreak. So, for example, whether employees have self-isolated, the body temperatures of their employees, and device location data. So all this information would be considered and classed as personal data. And because most of it pertains to an individual's health, it's also likely to fall within the subcategory of special categories of personal data. Now, as we know, the GDPR requires organisations to only collect as much personal data as is strictly necessary for the purposes being pursued. So data minimisation is key. So whenever you're asking an employee for their data, whether they're displaying symptoms, etc., whether anyone else in the household has been self-isolating, it should very much be taken and recorded, importantly, on a yes/no basis. In terms of the legal processing, so again, the GDPR requires organisations to have a legal basis for processing the data. We know that. In the context of personal data related to COVID, however, organisations can rely on the legitimate interest basis, contractual necessity. So, for example, you justify it by saying to ensure the health and safety and well-being of your employees, and also legal obligations. So, as I've mentioned earlier in my slides, we've got these new coronavirus laws now and government restrictions. So, you're legally obliged to do those due diligence exercises in terms of your staff and employees. So, in addition to identifying a lawful basis, an organisation, if you're processing special categories of personal data, then this activity must fall within one of these special conditions. And the most relevant one here is for public health reasons. Now, especially if an organisation is acting, and most organisations will, on the advice of public medical advisors, to carry out those due diligence on behalf of your staff to protect your employee base. So this would allow you to justify the processing of special categories of personal data relating to the coronavirus. However, you should always consider and, more importantly, record the basis for processing. So if you are collecting categories of personal data and all the special categories of personal data from your employees, as discussed, it would be prudent to at least review and perhaps update your existing privacy policies to reflect the new changes in the collection of that data from employees. It's also a good time, as is ever, I think, to update remote working policies. Remind your employees of those requirements and those obligations within those policies. As we know, home working has been very common during the pandemic, and that's probably set to continue. More people are frequently working from home. Now, a bit on the ICO. So the ICO have actually advised organisations to consider adopting the same security measures for home working as you would do in the office in normal circumstances. Organisations should also consider carrying out a data protection impact assessment as soon as possible if this has not already been done so. And this is because the GDPR requires this impact assessment for the type of processing which is likely to result in a high risk to individuals. With the collecting and storing of health personal data, it's probably likely that this would be caught by having an impact assessment carried out. So again, turning to the ICO, and hopefully none of you will encounter too many of these issues, but in the event of any personal data breaches, obviously these must be still reported to the ICO within 72 hours. That's not affected by COVID-19, that still remains the same. Saying that, the ICO have stated or have indicated there may be a degree of leniency if, for example, your organisation still has furloughed employees or a general weakened or lack of resource because of COVID-19, and that will be analysed on a case-by-case basis. But it's very much business as usual, stick to your data protection principles, and although there may be leniency, just keep in mind that you should still be adhering to your data protection principles as you would at full capacity. Next slide, please. So just to conclude then, obviously we've spoken about the variations and negotiation to contract and obviously how these have been affected, obviously using electronic signatures where you can. We've mentioned force majeure and frustration. So very important in force majeure, always check the express wording of the clause closely. Consider if there are any available actions before exercising the clause, or if you are offending the clause, and make sure you check if there are any notification requirements for etc. have that been dealt with, or any other collaborative wording. As I mentioned, there are various hoops to jump through, both for force majeure and frustration. But as mentioned again, I would always try and stay clear of frustration if you can, and always use that as a last resort. Data protection then, a common theme, we always advise reviewing and updating your existing privacy policies, your working from home documents on a regular basis anyway, so that very much should be done. And just be aware obviously of that new requirements in terms of health data for employees and staff, that you are correctly processing those special categories of personal data. And the ICO, as I've said, they will apply leniency where they can if you have furloughed staff or low resource. But I think that the key issue there is that, is that they may apply it, that there's not actually an express statement that they definitely will, and that will very much be taken on a case-by-case basis. Thank you very much, Beth.
Thank you, Dan. As I say, and thank you also for struggling through, clearly with a tickly cough, so great effort. So we've had a few questions during the course of the session, Dan, so if you take a moment to some more water and then we'll crack on with those. So interesting, we sort of briefly touched on this towards the end of your presentation, but perhaps we could go into a little bit more detail here, is that if our suppliers have let us down, or we have to pay more for the supply of goods and services, can we realistically claim frustration?
Yeah, it's an interesting one. I think, as I've mentioned in the talk, I think in the first instance, I would be saying, well, can another avenue be explored? Rather, if not, I think it'd be very difficult to allow frustration simply because the party has been let down by a supplier. So obviously, if we're taking let down by a supplier and you then have to go elsewhere and it becomes more expensive and therefore more expensive to perform, well, there's an actual case on this, and it's, if I pronounce this right, it's Sakaraglu and Nobly, I believe. It's 1960s case. And actually the defendant in that case had agreed to transport goods, in this example, to the claimant, and intended to do so via the Suez Canal. And I think subsequently that was closed to shipping, and I think the goods had to go right the way round. I think it was the Cape of Good Hope, I think, which increased the shipping time and cost significantly. Now, the defendant argued the contract was frustrated, but actually that was rejected by the courts because it was still possible to ship the goods, albeit it was more difficult and obviously cost more. But the crucial thing with frustration is the contract needs to be impossible to perform. And in that case example, and I think generally, as long as the contract can be performed, albeit by another substitute supplier, albeit a bit more expensive, then frustration is a very difficult argument to run, because the courts will very much take approach that you can get the goods or whatever you like, just a different avenue.
Thank you, Dan. Another question for you, this time on electronic signatures. It says, how do you deal with witness signatures for commercially sensitive documents now that more of us are working from home and still require documents to be witnessed? What would you suggest? Perhaps showing a signature page and covering parties' name to protect confidentiality? How do we deal with those difficult situations?
Yeah, I think that's a common theme. And as I've mentioned, there are electronic signature platforms such as Adobe Sign, DocuSign. Obviously, there are others on the market. They're very good at this, because what you can do is you can password protect those documents that you send. So if you're sending signature pages or the whole document, you've got a clear audit trail of who sent it, so you can verify the sender. You can actually see when it's opened, when it's signed, and obviously when it's sent back. So in terms of the software, if you have that, it does all that for you, and you don't really need to worry too much about it. Now, for normal emails, obviously this could be an issue. So I think to get around the whole e-signature process, which of course we can do now, I think you'd have to have some encryption or password protection, which I know you can do normally, sort of through Mimecast or PDFs, where the document obviously is sent in itself in one email, and then you send a separate email with the password to open it. Now, of course, as I mentioned, if you have deeds, obviously the physical witnessing is an issue there, so you wouldn't be able to do that by Zoom or Microsoft Teams. But what I would question in terms of the commercial documents anyway, obviously focusing on that for the point of today, is whether that commercial document actually has to be made by deed. I know you've got the benefits of obviously extending the limitation period to 12 rather than 6 by deed, but can it be signed normally in the usual way without having to witness the document? But if it does obviously need to be signed as a deed, then again, that section 44 of the Companies Act will allow you to do so, where the directors can sign the same signature page, albeit at different times remotely.
Thank you, Dan. The questions are coming through thick and fast at the moment for you. So one question, do I have to vary existing contracts? Can I not simply terminate and enter into a new contract? Would that be easier all ways round? Yeah,
I mean, of course you can. I mean, I think the the benefit to variation is that it keeps the original contract alive and kicking in terms of the parties' commitment. I think that said, if there are lots of amendments to be made to the contracts, obviously arising from COVID-19, then I think by entering into a new contract, that's fine. Of course, you can do so. But I would say that just make sure that you check the existing contract for any termination payments, which obviously may be required or triggered on termination, and check whether there are any kind of formalities to comply with. If there are those provisions in there, then it's probably likely, but albeit better to get in writing, whether the parties will agree to waive those termination payments, etc., in the hope that they're entering into a new contract on new terms.
Thank you, Dan. Another one for you. Will the forced closure of our business due to COVID-19 be classed as a frustration event?
Yeah, it's potentially. Again, that whenever I hear that word frustration, does scare me a little bit. But for example, if there's a second wave then of the coronavirus and businesses are again forced to close its premises due to government order, yes, that could be a frustrating event. But so long as there was no other meaningful way of that contract being performed, as I mentioned in my talk, there has to be that impossibility of having another avenue for that to actually to happen. So of course there would be a better argument for frustration there. But if there's a force majeure clause in the contract, then actually arguing frustration is again an uphill battle. That said, I know a lot of businesses, and this could happen again, have sort of made a commercial decision to close their premises in anticipation of COVID-19, preventative measure against the spread of coronavirus, and that could happen again on a second wave. Now, in that position, frustration is decidedly less clear. So whether frustration there could be relied upon in that circumstance, I think it'd be highly dependent on the specific reasons behind the decision to close a premises. I think simply closing them or cancelling an event or whatever out of an abundance of caution, for example, I think that would be very unlikely to give rise to frustration unless perhaps there was a sufficient explicit basis to argue that there's a statutory duty to do so. And like I say, that's purely because the hoops to jump through for frustration are very high bar.
Thank you, Dan. A few more for you still. Will a force majeure clause be caught by UCTA? Again,
potentially. It can be. So it's just like any other unfair commercial contract term. So in business-to-business contracts, force majeure clauses can be challenged by UCTA insofar as the clause does not satisfy the general concept of reasonableness. And obviously that's the crux of the UCTA arguments here. But generally speaking, force majeure clauses are regarded as reasonable, but they may still be deemed in circumstances where they're drafted so widely, or for example, it results in an increase in costs, or they cover matters which are within the party's control. That's when it probably would be deemed or may be deemed unreasonable. So obviously, the specific section of UCTA which deals with that point is section 3.2b. Which I obviously won't go into here, but the important part here is just to note that traditionally it's been proven difficult for the courts to actually interpret and apply that section of UCTA to force majeure clauses. And I don't think actually to date there are any case law, or very few case law, on UCTA's application to force majeure clause. Because I think one of the reasons is obviously given what's happened with COVID-19, force majeure, yes, is now more of an issue, but historically, the arguments around force majeure weren't down the UCTA route. They were purely down, have they been triggered in the force majeure clause? What do they include? Do they include specific lists for, sorts of actual terrorism, pandemics, etc., rather than the UCTA argument that they were reasonable?
I think from a litigator's perspective, because that's what I do primarily, I feel that there's this wave of cases that will be coming through, probably going to the best part of the next 10 years, arguing about termination of contracts, frustration, all related to COVID-19. So I think it's really a question of watch this space, and I think we'll sort of have a whole raft of decisions that we can refer to in the coming years. I think we've got time for one more question, Dan. Will my business be liable for a data protection breach committed by an employee during the pandemic?
Interesting. Not necessarily. And I'll say that because there's kind of two avenues to this. So obviously we know that following the Morrison's case, which has obviously come out recently, the Supreme Court has actually overruled the High Court and Court of Appeal and decided that Morrison is actually not liable for a data breach by disgruntled employees' actions. So I think taking that example, if you do have, for example, a disgruntled employee who may have breached sort of COVID guidelines from the company or data, for example, by saying, oh, so-and-so has coronavirus, and that obviously spreads around the office and wider. And there's a good case to argue that actually the employee was very disgruntled, acting on their own accord, and Morrison's case may come into play there. But I think generally, obviously this question extends to, therefore, employers' liability for breaches committed by the individual, and it won't capture all cases. So I think the key thing here is to obviously keep on top of compliance during the current pandemic, make sure that you have all those policies in place, because you could well be caught by actions of your employees. In terms of letting potential standards slip. You've got working from home policies, which are obviously very, very prevalent now. But obviously if data organisations say that they understand the pressures of businesses, like the ICO, for example, and they might apply leniency, well, that again, as I mentioned, shouldn't be taken as a given. It doesn't mean that all data protection rules will cease to apply during the pandemic. It simply means that obviously the regulators note what's going on. They may apply leniency depending on the business. But I think, if that does happen in that situation, you must be very careful, because you could still be caught by acts of your employees.
Dan, thank you very much for your presentation today and for fielding all of these questions. This brings this webinar to a conclusion. As I said at the outset, this is a third in the series of webinars we've been running each Tuesday. The final one for the time being, the fourth session, is on the 14th of July, and that will be focusing on business interruption insurance. That will be chaired by my colleague Adam Finch, who's a specialist on that subject. We will be following up this session with a link to that if you'd like to join us for that session, and we'll also send you within the next week a recording of this webinar so that you've got a permanent record so you can refer back to. But other than that, I'd just like to say thank you very much for joining us today. I do hope you found it useful. In one of the emails we'll send you will be a questionnaire. If you have time, I appreciate your time is precious, but if you could spare a moment just to give us some feedback. And importantly, any topics that you would like us to cover. We found these webinars have been really popular, and we're probably going to continue to run them on a regular basis. And clearly, if there are topics that are of particular interest to you, then we will be happy to cover those. So please do let us know. Thank you very much then. Goodbye.